Good morning, members. We have already formed a quorum. It is also time to start, so I call the meeting to order. That is the first meeting of the Inland Revenue Amendment Bill 2015. First of all, we need to elect a chairman. Nominations, please. Mr. Lo Wai Kwok, I nominate Mr. Christopher Cheung. Seconder, Mr. Andrew Leung. Mr. Cheung, do you accept the nomination? Yes, I do. Any other nominations, please? No. Well, in this case, I declare that Mr. Christopher Cheung has been elected as the chairman of the Bills Committee on Inland Revenue Amendment Bill 2015 uncontested. Congratulations. Members, thank you for your support. So I'd like to check with you if you think we need to elect a deputy chairman. No need for that. Well, in this case, we move on to the second part of the agenda, meeting with the administration. So please invite the team from the government to join us. We have a number of public officers from the Financial Services and the Treasury Bureau. The team is being led by Ms. Selina Yen. Good morning, Mr. Chairman. Good morning, members. We are here to brief you on the Inland Revenue Amendment Bill 2015. We've prepared a PowerPoint presentation. We'll use that to brief you on the content of the bill. If I may defer to Ms. Joyce Ho. Thank you. Thank you, Mr. Chairman. We'd like to further develop asset management industry in Hong Kong. Well, it is one of the fastest growing sector in Hong Kong. Towards end of 2013, the combined fund management business stood at $16,007 billion with a year-on-year growth of 27%. Private equity is one of the many important elements. As at the end of 2014, the total capital under management in private equity funds stood at $114.6 billion with a year-on-year growth of 16%, accounting for 21% of Asia's total capital under management. In private equity, currently there are about 390 private equity companies in Hong Kong. In the year 2006, we amended the Inland Revenue Ordinance so as to provide for the exemption from profits tax for offshore funds to align with other international financial cities. The current exemption provisions are as follows. Non-resident entities are exempt from profits tax for profits derived from specified transactions, covering those transactions an offshore fund would typically perform in Hong Kong, including transactions in securities and transactions incidental to the carrying out of the specified transactions. And specified transactions must be carried out through or arranged by specified persons, that is, in corporations licensed or registered under the Securities and Futures Ordinance. The current definition of securities does not include securities of a private company. So offshore private equity funds that make use of the services of specified person to derive profits from transactions in securities of private companies could be subject to Hong Kong profits tax. Moreover, offshore private equity funds are not necessarily managed by specified person as defined under the SFO. According to our understanding, half of the private equity funds are not managed by the corporations licensed or registered under the SFO. Therefore, we have a proposal. We'd like to extend the profits tax exemption for offshore funds to private equity funds. We'd like to clarify the position so as to attract more private equity funds to come to Hong Kong, and also hire local asset management, investment advisory services, and drive demand for other relevant professional services. Now, for this slide, we would like to look at the company fund structure for the private equity funds. Usually, it will be set up as a limited liability partnership with multi-layered structure. For a multi-layered structure, it means that we have one layer of or a number of layers of SPVs so as to hold the company. Well, for the legislative proposal in the bill, there are three parts to it. First of all, we want to extend the tax exemption to offshore private equity funds. We'd like to amend the definition of securities such that a transaction in securities in an eligible private company, that is portfolio company, will not be excluded from a specified transaction. To qualify for tax exemption, the portfolio company A must be a private company incorporated outside Hong Kong. B, within the 3 years before a transaction in securities in a portfolio company, did not carry on any business in Hong Kong or hold any immovable property in Hong Kong subject to a de minimis rule. Of course, we need to provide for some flexibilities. And in case of a permanent company, sometimes we need to have a place for storage, for display, then it will not be included in the definition for a permanent establishment. And we've also got a minimum rule, that is, you may not have capital commitments exceeding 10%. Moreover, immovable property may also be held. Again, it cannot exceed more than 10% of the total value. B, we will also propose to allow offshore qualifying private equity funds to enjoy tax exemption. To be a qualifying fund, the following conditions must be met. A, at all times after the final closing of sale of interests, the number of investors exceeds 4. That is, there should be at least 5, and the capital commitments made by investors exceed 90% of the aggregate capital commitments. And B, the portion of the net proceeds to be received by the originator and the originator's associates does not exceed 30% of the net proceeds arising out of the transactions of the fund. The purpose is to make sure that it is a collective investment tool rather than being held by the fund company by having majority holding. A resident person holding a beneficial interest of 30% or more in a tax-exempt private equity fund will be deemed to have derived accessible profits in respect of profits earned by the fund from specified transactions and incidental transactions in Hong Kong. This is to prevent abuse. And thirdly, we would like to amend the definition of securities such that a transaction in securities in a special purpose vehicle, SPV, will not be excluded from the definition of specified transaction. In other words, there will be tax exemption for the sale of the securities in the SPV. There will be an express provision to give exemption from payment of tax to an SPV in respect of profits derived from a transaction in securities in an interposed SPV or an eligible offshore portfolio company. This SPV is a investment tool specially set up, so it could be a corporation, partnership, trustee of a trust estate, or any other entity incorporated, registered, or appointed in or outside Hong Kong, and it could be wholly or partially owned by a non-resident person. But then for this SPV, it should be established solely for the purpose of holding directly or indirectly and administering one or more eligible portfolio companies. To prevent abuse, we'll also apply the deeming provisions. On this note, I would like to say that in November 2013, the FSDC released a report putting forth recommendations regarding tax exemptions for private equity funds and anti-avoidance measures. We've taken on board many recommendations from the FSDC, that is the Financial Services Development Council, like setting a 10% de minimis rule to allow portfolio companies to hold minimal immovable properties in Hong Kong. And as I have said, we would like to allow funds which are not managed by the SFC licensees to also enjoy tax exemption. So we have the so-called qualifying fund, so that they may also enjoy the tax exemption. And lastly, for the SPVs, again, we propose to exempt SPVs from the payment of profits tax. There were 2 rounds of consultation with the industry, and we have already taken on board some of the suggestions of the industry. The industry generally welcomes the proposal and urges for its early implementation. The bill will come into operation on the day on which the enacted Inland Revenue Amendment Ordinance 2015 is published in the Gazette. All right, the administration has given us a very detailed explanation, so members, you may now speak. First of all, Mr. Charles Mok. Thank you, Mr. Chairman. I can see that, first of all, for the administration's proposals, they will apply to the so-called private equity funds. I don't think I can count myself as a member of the financial services industry, but in the past I had some dealings with such companies. My impression is that private equity funds in Hong Kong usually hold companies just before listing rather than set-ups or the VCs. I don't know whether it is a coincidence or not, but then according to your definition, if a company is to invest in an emerging enterprise, like in the form of a venture fund or venture capital, would you also include such companies in the scope of your bill? Would like to take up this question? I'll try to answer. And then Mr. Chiu from the IRD can supplement. I think Mr. Mok has made an observation. I think this is the process of the development of private equity funds in Hong Kong. In recent years, as a base for private equity funds, Hong Kong has gained significance. Just now, Mr. Charles Mok said that sometimes the funds were found to be investing in companies approaching maturity on the verge of getting listed. In addition, I think we found that the spectrum has been expanded regarding the industries to be covered. As well as the stage of the development of the business that the investment takes place. I think the spectrum is rather wide. So for the various concepts and the structures that I referred to or we referred to, I think they will apply to different stages of the spectrum, like including venture capital. If they have invested in such, and if they meet the various conditions that we've set out, that is specified securities will include private equity companies, and also the portfolio meets the requirements of a qualified fund. And then in relation to the minimum number of investors, there shouldn't be fewer than 5 investors. And then for the originator's investment cannot exceed more than 10% upon the close of the sales. I think they are sort of in line with our definition concerning a collective investment.
And if it's an SPV, then we would also allow that if it meets certain requirements. So given the situation, our scheme would allow them, whether they are at a particular stage of development, they would still be eligible for that exemption. Chairman, I can supplement here. Well, under the IRA bill that is presented, well, for exempted private companies, that would also cover all the newly established companies or early starts, and some new venture sectors. But then I'd like to point out that for such exempted companies, they are not engaging in business in Hong Kong, and in simple terms, they do not have they do not hold any immovable property in Hong Kong. Chairman, precisely what Mr. Chiu was saying was what I'm worried about, because we often think that Hong Kong should encourage more early starts to come to Hong Kong. My impression is that according to my contacts with those from these sectors, many of them are involved in some late-stage investments. That's why originally when I heard that for such private equity funds, they will be exempted from profits tax, I thought that is something good. So would we be able to encourage or attract more early starts to come to Hong Kong? But then you also look at the targets of such companies, and they also have to be overseas companies. If that is the case, then Hong Kong's financial sector will continue to enjoy the status of a financial sector, but then for these companies, they will not be able to benefit from that. Well, you talk about hundreds of companies in Science Park, and Cyberport also has a number of companies. You also support innovation and technology, but then under this bill, apparently they will not be supported. So on the contrary, you're actually encouraging those which are investing in Hong Kong, and in terms of tax concession, that is something that they will consider. Of course, they will also be looking at other factors, but then apparently they'd rather invest in overseas companies than in local companies. For some late stage or early starts, when they make investments, most of the investments would be in overseas companies. So policy-wise, if you're still inclined towards favoring investment in overseas companies, then you will not be able to encourage these companies to invest in Hong Kong companies. So why is that policy so strange? Because on the one hand, you're encouraging innovation and technology, and you would like to attract more people to join these sectors so that they can start their own business, and you said that you would support them, and the government would also be setting up funds to support them. But then apparently for private funds, you do not support them going into these sectors. So the government's policy is giving people the impression that apparently you're running in two directions, so you're not able to help the new startups. Government officials. Thank you, Chairman. Thank you, Mr. Mok. Well, today we are talking about our proposal, and our proposal is about what we introduced in 2006 about overseas funds with regard to the exemption on profit tax. We are now extending it to private equity funds. Number one, we believe that the scope has been extended already, so that the beneficiaries have increased in number. So that's point number one. Number two, concerning the point made by Mr. Mok, that is, if private equity funds would like to invest in local startups, then they will not be able to benefit. In fact, in the process of consultation, we have discussed that with the sector. We noticed that. But as we have said, if we were to exempt some companies' investment in local companies, and as a result, if they are able to enjoy exemption from profit tax, then the scope involved would be a lot broader. And if we were to do that, then I believe that we will have to go through a very extended consultation, and we will also have to look in depth into many issues. It's not just about the investment by private equity funds. What about other different types of investment? And if they're also investing in Hong Kong companies, then if they're also asking for equal treatment in terms of tax concessions, then the scope would have to be very clearly looked into, and also on how these should be defined in order to ensure that we will not be creating a situation whereby there would be a lot of abuses. So these are things that we will have to consider very carefully. That's why when we talk to the trade, they would welcome our initiative to do what we are proposing to do today, so that, well, for the tax exemption for offshore funds, the mechanism will now be extended to private equity funds. And in the future, if, as Mr. Mok just suggested, if private equity funds are investing in Hong Kong portfolios or Hong Kong companies, whether they should enjoy tax exemption, that will have to be considered and discussed very thoroughly. And in the process of our discussion with the trade, they believe that the current proposal is feasible. In other words, we will go for this first. So we will extend the exemption to private equity funds first, and then for the rest, we will consider that later. Chairman, I just have one point to make. Well, Ms. Yan was referring to the sector, so she might be referring to the fund sector, but then I don't think she is referring to the portfolio companies, because they are the beneficiary, because they'll be receiving the investment. But then I understand that there might be many areas that you will have to consider. But can I ask you to supplement one piece of information? That is, at present, do you have any data to support this? That is, do you know how many private equity funds have been set up in Hong Kong? And in terms of their investments in Hong Kong, how does that compare with their investments overseas? So what is the ratio? Is it 50-50 or 90 overseas and then 10 in Hong Kong? Or will you be able to tell whether or not they have invested in securities or in portfolio companies? Under your definition, that is in securities, and also securities in unlisted companies, and also investment into the capital of certain companies. Because what I'd like to see is, if this scheme is passed, then will the situation get worse? So much so that we will have to review it. So have you got the statistics? Because I'm also very concerned about these companies. And of course, as a financial services center, there is no way that we have to make sure that all the investments are in Hong Kong. But then if you see a declining trend, then that might be a problem. You will have to look into it. Mr. Mok, I think he's concerned that if you exempt overseas private equity funds, then for Hong Kong registered companies, there might be unfair competition. Is that right? Well, I was saying that well, the money will go to portfolio companies outside Hong Kong, and as a result, for companies needing funds, they might find it more difficult to raise funds. That's what I'm concerned about. Yes, Deputy Secretary. Thank you. Well, I understand the question raised by Mr. Mok, and also the reason why he would like to get the information. All right, we will try to see if we can get it. Well, as you can see, for private equity funds, they are not really regulated by the SFC. That's why we might not have very systematic data about how they work. But then given our close contact with the sector, we will see if we can get hold of the information referred to by Mr. Mok, that is in the past and at present for private equity funds, to what extent they've been investing in Hong Kong or in overseas. But then I'd just like to add this. For private equity funds that we'd like to attract them to come to Hong Kong, and if they invest in Hong Kong portfolios or non-Hong Kong portfolios, but then as a financial center and also as an asset management center, both investments would be good to us. So if they're able to set up in Hong Kong, but then for the portfolio companies that they invest in, they may not be in Hong Kong. They can also be non-resident companies. That would still be welcome, because if they're able to set up a base in Hong Kong and engage in investment activities and to a overall financial sector, that would be good. In particular, in terms of the application of our tax rules, and also the hiring of our financial services talents, and also the engagement of professional services in Hong Kong, I think that would be a good move. So all in all, on asset management and private equity funds, well, as a hub for such services, I think that would be good for our overall development. Next, Kenneth Leung. Thank you, Chairman. I have many questions. First, I'd like to know this. This is technical in nature. First, in the amendment bill, with regard to offshore funds or specified transactions and so on, you have not changed that whatsoever. Is that right? Is my understanding correct? There's been no change whatsoever to these terms. So other than specified transactions, sorry, I should put it this way. So for offshore funds and also specified persons, well, for these two terms, there's been no change to the definition whatsoever. Is that right? Well, Chairman, concerning the question raised by Mr. Leung, can I put it this way? Well, for specified persons, for specified transactions, at present, it would refer to private companies, i.e. exempted private companies, they would be included. And then for non-resident person, there is no change to the definition whatsoever, so it will remain the same. What about offshore funds? Well, for non-resident funds, there has been no change whatsoever. My second question, and then for specified persons, I think Mr. Leung, you were referring to this. There has been no change too. Well, my understanding is that for specified persons right now, so it's under the SFO, the Securities and Futures Ordinance, you have different categories of specified persons, so they are registered persons. So under the SFO, from time to time, you would add in different categories, and that would also automatically apply to the IFO, to the IRO concerning specified persons. Is that right? So there is an automatic mechanism for this change. Is that right? So you're referring to whether or not specified persons follow the definition under the SFO? That's true. In other words, if there is any change or amendment to the SFO's definition, then there will be an automatic and equivalent change to the definition under the IRO. So for royalty benefits, so long as you can meet all the conditions, there will be tax exemption. In other words, for royalty portfolio companies' dividends, and also for any subsequent sale by the overseas funds in securities of these companies, they would also enjoy tax exemption. Is my understanding correct? Well, Chairman, the honourable member was referring to offshore funds buying or selling such private companies, so long as they can meet the conditions that they do not have to pay tax. With regard to dividends distribution, very often you have this limited partnership, and there is a distribution list, and on the face of it, yes, they may not have to pay tax, but then I also would like to add, Hong Kong as an asset management center, there are many asset managers, and if part of their remuneration is in the form of distribution of dividends, then the IRD would have to look into it to see if the service charge would also involve such distribution. Okay, so I'll ask you later. I think this is a very complicated issue. And next, looking at the portfolio companies, two of the important conditions are that they will have to be incorporated outside Hong Kong, and number two, such companies are not going to carry out any business in Hong Kong other than some insignificant or de minimis activities. But then, if I look at it from an offshore fund's perspective, if it invests in a Hong Kong portfolio company, as Mr. Charles Peter Mock just said, well, looking into that, well, if there is a dividend, well, other than what you said, dividend disguised as a service charge, dividend in itself is not something that should be subject to tax. And secondly, based on the IRO's basic principles or overriding principles, in other words, for capital assets, they should not be taxable. So based on that principle, would you still be applying the underlying principle of the IRO in looking into this? And in the end, if an overseas fund in the end sells the shares of a portfolio company in Hong Kong, so would you apply this principle to determine if it's taxable, or would it be done across the board, so that once you introduce this amendment bill, then for the other transactions that would not be covered, they would all become taxable?
To answer members' question, the proposed amendments will provide a certainty to the private equity funds. Well, put simply, now if a company is meeting the requirements in the bill, then it will be exempted from tax. Otherwise, we'll check whether the profits originate from Hong Kong and whether it is capital in nature, and so it is not taxable. So the current principle of taxation will not be affected and changed. I'm not going to pursue this line of the questions. It will be far too long. Mr. Chiu, what about dividend distribution? Now you are telling us you are trying to see whether it is bona fide dividend or whether it is for the payment for the services of the investment managers or advisors. I think you will examine this. I want to know about the criteria that you adopt. Would you look at the profits of the company and compare it with the dividend distributed? Perhaps there isn't any standard for you to benchmark. A portfolio company may make a lot of decisions to distribute their funds. In a private company, it will be difficult for you to check the distribution level. So what will be the criteria for you to carry out the so-called investigation? Mr. Chiu. Well, this is about the manager managing the assets, and he provides service in Hong Kong, and it is a matter of the reasonable payment for his service. Generally speaking, such managers are sort of senior executives of PE firms. When we judge whether he's charging a reasonable payment, we usually try to compare. Now, we have this 2 plus 20. That is, the basic management fee will be 2%, and then something like the bonus will be 20%. It is a simple rule so as to tell us whether the manager is charging an unreasonable fee. This is one way to look at it. Of course, in individual cases, we have to find about the nature of the service provided by the manager, the resources that he has to use, and then we can make adjustments, plus or minus. Basically, we have to look at the market position. Mr. Chiu, 2 plus 20, where do you get this criteria? And can you further explain why you have got this 2 plus 20 rule? Mr. Chairman, I asked a question. Mr. Chairman, the member asked a question concerning the 2 plus 20 formula. Well, it is a commonly seen practice in the industry. 2% means 2% of the value of the portfolio. It is the annual fee charged for the service. 20% refers to the scenario in which the portfolio has seen an increase in the value, and then the annual increase will be regarded as 20%. Of course, I need to supplement. There are many conditions that have to be met, and for each and every fund, there will be some slight variations. Basically, the concept is 20% plus 2% plus 20%. Mr. Kenneth Leung, why don't you wait for your second round of questions? Dr. Low is waiting for his turn. Thank you, Mr. Chairman. The purpose of the amendment bill, as set out in the presentation, is clear. This is to promote the development of PE funds in Hong Kong. So if I may try to draw a comparison, that is the prospects of the PE industry in Hong Kong. According to the figures given, towards the end of 2013, the combined fund management business in Hong Kong was valued at 16,007 billion Hong Kong dollars. The year-on-year growth was also good, 27% from 2012, and we have got the status of being one of the top asset management hubs in Asia. That's for asset management. For private equity industry, as at end of 2014, the value was $114.6 billion US. So when you compare that with the total fund management business, it accounts for a small percentage only, and also the year-on-year growth is less significant than that of the asset management industry. This one is 16%, while the asset management is 27%, but it still accounts for 21% of Asia's top capital under management in PE. Now you're going to exempt the profits tax. So what is your assessment? How do you see the prospect of the development of PE industry in Hong Kong? Moreover, elsewhere in Asia, many markets are also promoting the development of the PE industry. Please tell us about their tax exemption initiatives. Ms. Yan. Thank you, Mr. Chairman. Thank you, Dr. Low, for his question. A few points here. First of all, the overall asset management in Hong Kong. I think we can still claim that we have a competitive edge. This is because, geographically speaking, we are in the heart of Asia. We can make use of our existing strength, and we have a lot of professional services, and we can serve global fund management businesses, in particular if they want to benefit from the growth in Asia. In terms of investment, they can use Hong Kong as a base to invest in the Asian markets, of course in particular the market of our nation. At the same time, to manage their existing assets, in particular for many years in Asia, we have seen a significant accumulation in assets, in particular the asset growth on the mainland. So Hong Kong can be well positioned to act as the base to manage the assets in Asia. For PE, of course, we like to expedite the growth in this area. For the figures that we've presented to you, the nature of PE is such that it is in a highly regulated industry. So we have to get the figures from the industry itself. However, our understanding is that there is a huge potential in the development of PE, along with the potential to develop asset management as a whole. In particular, when the investment matures, And if they want to identify an exit, that is to list the company, then Hong Kong is a good place as a choice for listing. Lastly, for the bill presented to you, once the bill has been enacted, you may want to know about the rate of growth that we are expecting. Of course, we can't be scientific, but we do think that it will be a momentum for growth. Perhaps for members' reference, since year 2006, when the profits tax for offshore funds have been exempted, so we've seen a growth of 2.62% from 6,154 billion dollars in 2006 to 160,000 billion dollars. As to how we compare with other markets in Asia, well, I think they have similar initiatives as we have proposed. Like in Singapore, they have also got exemption for offshore funds. So just now I have given you the comparative data, and you can see that they have also got similar initiatives. Do you have any follow-up, Dr. Low? What about the development of PE on the mainland? We have been told about the miracles like Alibaba, and recently I have met the persons involved in the initial investment in Alibaba. I think it is not for us to be jealous, because it is the sort of opportunities available on the mainland. So I just wonder if the potential on the mainland is even greater, and I want to know whether we are able to have a share. I think we all hope that there will be more rapid development on the mainland so that we can also benefit from it. Ms. Yan, I think, of course, Dr. Low's observation is right. That is, PE is being highly and rapidly developed on the mainland. Of course, Hong Kong can play a very important role. They can work through Hong Kong so as to introduce funds from all over the world to invest in portfolios on the mainland. On the other hand, mainland funds can also be channeled via Hong Kong to invest elsewhere. When it is mature and when listing is considered, now Hong Kong is well connected with the mainland, and so we have a competitive edge. So I believe that the current proposals in the bill will be of great help. Next, Mr. Sin Chung Kai. Probably I won't be asking questions about the tax exemptions. I can't quite remember the details. What about the current policies and regulatory measures over the PE in Hong Kong? I think for PE, it is targeted at the institutional investors. I suspect that the degree of regulation will be low. So please explain. Any need for registration, any need for the investment managers to be licensed for PE? of course, you have certain conditions for them to qualify. Does it mean that they don't need to get registered with you even if they're seeking exemption? For the question asked by Mr. Sin, the following is the current position. It depends on the area of business invested by the PE. Sometimes it may involve securities as defined under the SFO.
So investments in securities in particular, investments in listed companies' shares, and if they carry on business with that, then of course they would be subject to the regulation under the SFO, and they will have to get appropriate license. So according to our observation, as I said earlier, in the sector, about half, according to our understanding, have licenses issued by the SFC. But then for the remaining half, why do they not need such licenses? That's because of the investments that they're involved in that might not have to do with securities. As I said, very often they would invest in portfolio companies in different sectors. So basically they're investing in the assets of private companies, and as a result they are not subject to the SFO's regulation. So if it's purely on regulation of private equity funds, then that would depend on the items of investment, whether they would be subject to the SFO. Concerning our proposal today on tax arrangements, so we have come up with some definitions about private equity funds, in particular for qualifying funds. That's for the purpose of inland revenue arrangements, so it's not done for the purpose of regulation. That's why, as investments in other companies, so when you buy or sell a company, or when you inject funds into a particular private company in different sectors, so you will be subject to the regulation in the different sectors, not rather than under the SFO. So that's the simple reply. Yes, Mr. Sin. So I'd like to know more about the approach. So what I have in mind is, so for the managers of private equity funds, you can regulate them. And you will have to define this, and if they want to get the exemption, then they will have to be registered. So for the purpose of collecting statistics and so on. So even if they get registered, they may not be able to get the status. And then you can look at what they're involved in. I think that's also a good way for you to collect the data, whether it's for statistics purposes or whatever. So have you considered this approach? Because right now, well, I'm not calling it, I should not call it a loophole, but then you're actually giving them a chance so that they can get the tax exemption. And then after they've got the exemption, so whether they call themselves private equity funds, it doesn't really matter, so long as they can get the exemption. They will benefit. But of course, they would also have to meet the three conditions. So they can only invest in private companies' securities, and they will also have to meet the definition under the fund. And also, if they use SPV or special purpose vehicles, if they can meet all the three conditions, then of course we will then have to consider whether they can get exemption for profits tax. So would it be equivalent to private equity funds registration? Not necessarily. So we still have to look into this. So today we are just looking at the tax arrangements, and we are making this proposal. As regards whether there should be a registration system, we have to know the purpose of this registration system. what is it trying to achieve, and under what circumstances would they need to be registered. So I believe that we will have to take it up again with the sector. What's the purpose, and also under what circumstances would they be required to be registered? And of course, we agree that if there is a platform so that we can have a better idea as to the developments of private equity funds and the trends and so on, would be more than happy to look into it. So I suspect that by approving our proposal today, on the one hand, that would also help us better grasp the situation. But then, for the three concepts that we are promoting today, on specified persons, we are just putting in place one additional arrangement for them to do it. So if they themselves are already specified persons under the SFC, they can already benefit. Yes, sir, Alan Long. This is the first round of questions. Do you have any comments? If not, then we'll move on to the second round. So I'll wait till the second round then. All right, Kenneth Long. Thank you, Chairman. Well, has any other member mentioned that we should hold a public hearing by inviting the deputations to come along? I hope that there can be a public hearing on this bill. Chairman? Well, I'll ask the Secretariat to prepare for that. Well, let me continue to ask questions. Well, when the administration came to the Financial Affairs panel, well, I think Charles Mock also raised a similar question. That is, you said that portfolio companies will have to be established overseas and they are not allowed to carry on business in Hong Kong, or else they would not be exempted. But then in the long run, it's not just about financial services or tax matters, or whether we should encourage funds to set up their base in Hong Kong. But then it would involve a broader issue of Hong Kong's macroeconomic development. So under the IRO, once this amendment is passed, then I think you should consider this. That is for Hong Kong portfolio companies. Well, I'd like to put it on record here. If they carry out certain business in Hong Kong, for example, environmental protection, energy, and also high-tech projects. Another idea is new startups. So long as they have been set up for less than 10 years, so if they can meet these criteria, then I hope that the administration can come up with a new bill so that after this bill is passed, then these overseas funds, if they are investing in such local portfolio companies which operate in Hong Kong, then they should also be exempted from profits tax. I'm not saying that the companies' profits tax, the portfolio companies' profits should be exempted, but then the leakage is that the leverage is for the overseas offshore funds. For the overseas funds, once they have invested in such a local portfolio companies, then the profits arising from that should be exempted. So has the administration got this in mind? And also, once this exemption is granted, I think the most important thing for you to look into is the cost benefit. So which will derive more benefit for you? And if you have the new exemptions, and if as a result many new companies will be set up in Hong Kong, then in fact you would not be foregoing a lot of tax, because these companies operating in Hong Kong will have to pay profits tax in Hong Kong. You're just exempting the profits tax for the investor. So can the administration consider this? Who is to respond? Deputy Secretary. I'd like to thank Mr. Leung for his suggestion. In the long run, we also have to have more comprehensive consideration about this. And you also talk about environmental protection, high-tech, and also energy development. So you're specifying certain traits under, whereby such arrangement would apply. So if we were to exempt certain portfolio, if we were to introduce exemption on investment in some portfolio companies in Hong Kong, then that would involve more comprehensive consideration. And in the long run, we'll be taking a look into that. So mainly, this will affect certain specified sectors in accordance with Mr. Leung's suggestion, whether or not there is a consensus in the community as to what these sectors should be and what the tax arrangements should be, whether there would be some scrutinizing procedures and so on. So as I said, the areas involved would be a lot more, and therefore we can only consider that later. But then, once again, I'd like to thank Mr. Leung for his suggestion. Next, Alan Leung. Mr. Leung can continue. All right. So I may ask until the end of this meeting. Well, I'd like to put this to Mr. Chiu. So it's a technical issue. Are there any pragmatic or practical problems right now? I'm not referring to specific cases. It's not appropriate for me to refer to cases. So looking at this formula, so if there is any distribution higher, then here, then will you be looking into that? So will you be opening a file to investigate those cases? And also, would you accept some overseas funds managers or consultants or advisors who might give you some form of a document like the APA, so that there can be a certain arrangement, so that they tell you that, all right, this is the way my service vehicle is operating, then would you be charging me profits tax for that? So would you be prepared to accept this kind of de facto APA arrangement, Deputy Commissioner? So let me try and answer this question. In determining whether the funds manager or advisor in charging the service fee is reasonable, then we will have to look at the established formula adopted in the trade. But then, as I said, it depends on the individual cases and also the circumstances of the case. So in terms, we will have to look at the services provided by the fund manager or the consultant before we determine whether or not the remuneration received by him is reasonable. And just now it said that whether the IRD would consider coming up with some advanced pricing arrangement, APA, so that fund managers or the IRD will have an advance agreement as to how that should be calculated, so that the fund managers would also find it reasonable. Well, the IRD is positively considering this, and at present what we have been dealing is, well, we have got similar cases, and if the honourable member has such cases in mind, then he can also refer those cases to us. We'll be happy to look into that. I'm not going to refer the cases because it's not appropriate for me to comment on that. Well, the second thing that I'd like to know is, so I'd like to refer to some tax-related matters. Okay, the IRD is dealing with so many cases. Including tax exemptions for these funds. You're also dealing with some international tax laws, including the exchange of information and so on. So I've heard that actually your staff are working overtime a lot lately. So you do play an important role. Do you have plans to increase manpower? Well, thank you for your concern. Well, in fact, IRD colleagues, according to a code of practice, we will try our best to do our job. And at times, if we have to work overtime, then we'll be happy to complete the task. But then in the course of it, we've been monitoring closely as to whether or not we have adequate resources to do our job. That's why in the coming months, if we need additional resources, we will apply for extra resources. So we are considering that, and we are making preparation for that. Well, I've no further question for the time being. Well, who else would like to ask questions? If not, then I'd also like to questions, because in the paper we can see that you said that these funds must not hold Hong Kong assets exceeding 10% of the total asset. All right, property prices are rising, security prices are also rising. So how do you define the 10% threshold in determining whether or not they should be exempted from tax payment in Hong Kong? Well, Chairman, I'll try to answer the question. Well, under the amendment bill, the spirit is that for the portfolio companies, they should not carry on business in Hong Kong, and they should also not be holding any immovable property in Hong Kong. So from time to time, what we'd like to do is this, but then in the actual operating environment, with so many portfolio companies, they might have some business links in Hong Kong, or they might also have some insignificant immovable property in Hong Kong. That's why we have this safe haven, and that is 10%.
In the course of consultation with the industry, both have agreed that 10% is about right. As to how we see it, when the portfolio company is sold, then we count 3 years backwards. Say if immovable property has been held and if the value accounts for less than 10%, then it will be acceptable. Mr. Chairman, I agree with your point. That is, the asset values may fluctuate. Sometimes we cannot meet this particular requirement, but still we need to have a threshold. 10% is being proposed in the bill. Next, Ms. Chen Yun-hen. Thank you, Mr. Chairman. Investors may go offshore. Now the government is saying that we should provide exemptions, while others may try to get the exemption by round-tripping. I'm not sure how the government is going to do it. Now you say that it's a PE and so there will be exemption. But in fact, I can work through certain channels and then I can avoid the tax. So what are you going to do? I don't quite understand the details. Can you elaborate? RD or the Bureau? I'll try to give an overall reply and Mr. Chiu can always supplement. If I may provide some background information. Currently, when we have collective investment tools, they are already given tax exemption. In the year 2006, we started to introduce the tax exemption for offshore funds. For the current proposal, what we want to do is that for the tax exemption introduced in the year 2006 for offshore funds, it should be extended to private equity funds. Ms. Chen was concerned as to whether someone would disguise as a PE and so try to benefit from the tax exemption so that there can be tax avoidance as a result. Now, we have got a few concepts here, and we require the PEs to meet certain requirements before they can benefit. First of all, specified persons. If we are talking about specified persons under SFO, then there will be the eligibility question, but then PEs may not be governed by the SFO, and they may not necessarily be investing in the securities of listed companies. On the contrary, they like to invest in private companies, and such will not be governed by the SFO. Now, we are saying that if certain conditions are met, then we can consider granting tax exemption. First of all, private company. And for the business invested in, it cannot be a company registered or incorporated in Hong Kong. So it must be an offshore company. And then the major requirements that we can't be talking about 2 or 3 persons pulling together to set up a so-called PE fund and seek exemption. Our requirement is that the number of investors must be 5 or more, and then the originator cannot account for more than 10% in relation to his own investment. So we want it to be a more open investment item rather than having 2 or 3 investors making investment somewhere and come back to Hong Kong to claim exemption. And then the non-originators must account for the majority of the investment. And we have this rule on the threshold at the final closing of sale of interests. And then as far as the operation is concerned, we say that they can't invest in Hong Kong, but then they have a 10% exemption. Say, for example, they may have an office or they have a place to display their goods. And then if they want to set up an SPV, that is a special purpose vehicle, the SPV can be set up, but then the nature of the business is such that it is for the purpose of management rather than investment. So with certain requirements here, so as to strike a balance. On the one hand, we want to attract PEs to set up a base in Hong Kong to develop their business, because after all, we see a lot of potential in this regard. On the other hand, we are equally concerned as Ms. Chen, that is whether this will easily become a loophole. Therefore, we have imposed a number of requirements, hoping that we can reduce or stamp out the loopholes. Mr. Chairman, yes, please follow up. I'm grateful to the officer for the detailed explanation. I tried to see it the other way round. In the year 2006, when the exemptions were given, PE was not included. Now you want to include the PE. There must be reason back then. Now it seems that you're saying that you're confident and you want to drive the development of PE in Hong Kong. Are you sure that the concern back in 2006 is no longer valid? Chair, I think you understand that the fund managers come from various backgrounds. I just wonder if the concern in 2006 can be addressed or has already been addressed. Well, the managers can always outwit your requirements or rules. Now, in 2006, you wouldn't agree to it. Now you say that you will liberalize, and there must be a reason. Well, it's very easy to find 5 investors. I don't know if Mr. Leung would agree with me, given the huge wealth accumulated. It's easy to find 5 investors. So in 2006, you were really worried. Please assure me. Otherwise, Hong Kong will be involved, and then there will be big trouble for us. You know that there is this bank which has left Hong Kong. I don't want to go into the details, but then the financial crisis has exposed a lot of things for us to see. So in 2006, you didn't include PE. Now you want to include the PE. Are you really confident? In addition to what you have said, please tell us why the Hong Kong government is willing to change the policy. Now you want to drive the growth, but you need to be cautious. Ms. Chen, I think you have a good memory about the amendments to the ordinance. So let's get an answer from Ms. Yan and see if she can satisfy your concern. In year 2006, we were trying to promote the industry. At that time, we looked at the prevailing SFO, and we extended the concept of securities. Other than onshore funds, offshore funds were also covered. But still, we're talking about securities as defined under SFO, that is, transactions of the shares and securities of listed companies. A lot of work is involved whenever we want to amend the law, and we have to gauge the development of the industry, and then our policies should correspond. I've read up the papers regarding the 2006 exercise. I think both the government and the Legislative spent a lot of time on that piece of work, and the Legislative spent a lot of time on scrutinizing the bill, whether there would be loopholes, abuses, etc. Had PE been included on that occasion, of course, it would have been good, but then there would have been technical difficulties because at the time we were taking the definition of securities under SFO. Today, we are having a wider or more broadly defined concept. We have to find out how we can operate. Since year 2006, I think the asset management industry has undergone rapid development. We believe that since we can tie in with the mainland development, we have seen rapid growth, and of course we've made reference to overseas counterparts. We believe that it is now the right time, and we can resolve certain technical difficulties, and therefore we have presented this bill for your consideration, so that we can ride on our developments. As we have said during the consultation with the industry, we've emphasized that while we're facilitating and promoting the development, we must also bear in mind that this step will not create loopholes for tax avoidance or evasion. So today, we have come up with a bill with rather complicated concepts. So on the one hand, we want to facilitate the growth of the industry. On the other hand, we believe that it is the right time to launch the initiatives. For the technical concerns, I think we are ready to come up with something which is enforceable by the IRD. I think the IRD is confident that they can enforce the new requirements. Any follow-up, Ms. Chen? I can only say that I have faith in their words. I can only trust that they are able to resolve what they couldn't back then. Now we've got more funds from the mainland. Well, still, in the past, you didn't give exemption to PE. Now today you are. As I have said, I welcome such a move. However, the government must think hard. You have imposed a number of conditions. You have said that the number of investors would be 5 or more, and then there will be the threshold of 10% as well. You want to know about the economic benefits to Hong Kong as a result of granting tax exemption, so that you can judge whether it is worth the while. Mr. Chairman, our understanding is that today we are focusing on offshore private equity funds. Basically, if they don't have business in Hong Kong, and we're talking about offshore business, in principle, they don't have to be taxable. So the tax revenue forgone would be insignificant. Now you may want to know, while on the one hand I say that it is not taxable and yet we'll grant exemption. Well, we want to have certainty. We want to clarify the legal position so that the industry and the ROD can have a clearer picture. In the past, many industries have directed inquiries to the ROD, and we hope that the bill can provide for legal certainty. As to the benefits, we believe that there will be economic benefits. In particular, when they set up a base in Hong Kong, they need professional help in terms of taxation, asset management, legal services, among a host of professional services. So they have a need for such a service.
Yes, Mr. Chiu from the IRD might be able to help here. Well, Chairman, in amending the IRO this time, well, when we refer to overseas private equity funds, what are we referring to? They are a non-resident company, so they are not engaging in any business in Hong Kong. And then for the portfolio companies, they are also not in Hong Kong either. So they have to carry out business elsewhere. And therefore, our policy is that when the private equity fund takes Hong Kong as a base, so that it would be able to take advantage of Hong Kong's technology, for example, talents and also professionals here. So for the tax exemption, it's just about the private equity funds acquiring portfolio companies outside Hong Kong, then that would not be taxable. But then for the fund managers, at present, their income would be taxable. Anything else? Kenneth Leung and Alan Leung. Now it's your turn, Alan Leung. Thank you, Chairman. I hope that my question is out of my ignorance. But then from what I heard from the Deputy Secretary, I had some difficulty because the Deputy Secretary was telling us on the one hand that, well, these private equity funds under the present bill, which is seeking approval from this council for tax exemption, in fact, they are not paying much tax, and therefore we are not really foregoing large amounts of tax. So, Mr. Chairman, you asked this question, and you hit the nail right there. So there was a question about the benefit of this policy, because we haven't really seen the merit and we have already seen the demerit. But then the Deputy Secretary was saying that, well, we haven't been charging a lot of these tax and we are not going to charge it anyway. So we're just trying to provide for some certainty so that definitely we will not be charging them tax. But then I have some doubts about this. So I hope that the Deputy Secretary can explain that a bit further. Next, what I like to say is in Hong Kong, if we want to attract these private equity funds to come to Hong Kong to engage in what we would call speculative activities, so that would not be benefiting Hong Kong people too much. They are not really substantive investment, so some professionals might be benefiting, but then the majority of Hong Kong people will not be able to benefit. So it's not about setting up a factory here so that Hong Kong people can go and work there. So basically, they are just making use of some financial techniques to engage in speculative activities. All right, so that's my definition. So I don't really see how Hong Kong people can benefit from that. So maybe the Deputy Secretary can elaborate a bit further. So without this amendment bill, it said that we won't be able to charge any tax. That's why there is no demerit to us. So if that's the case, according to the Deputy Secretary, then on that basis, I'll discuss this further. So my question is, can the Deputy Secretary confirm, or with the assistance of the Commissioner for Inland Revenue? So without this amendment bill, we have not been able to charge them any tax at all so far. So with this bill, actually we have not been able to charge them any tax anyway. So there is no question of foregoing public funds. And that's point number one. And number two, have you done any assessment so that for the Hong Kong SAR, is it that we are so unattractive that we can only rely on offering tax exemption before we can, in order to make ourselves attractive? So have you done any assessment without this amendment bill? Without this bill, is it that these so-called private equity funds when they engage in speculative activities, they will just move away from Hong Kong because there is no value in engaging in the business in Hong Kong. So what we can offer is so we can only offer tax exemption in order to attract them to come. And certainly, have you done any assessment? Just now, according to the Deputy Secretary, some professionals will benefit. But then, with regard to this tax exemption under the bill, how much GDP can we increase? So to make it broader, so can you put it in more concrete terms? So how many professionals will benefit? Have you done this assessment? Because it depends on how you answer the first question. There is still the situation of weighing the pros and cons. So you will have to weigh everything. You must have measured the pros and cons on both sides before you come to this conclusion, right? So can you tell us that? Deputy Secretary, thank you, Chairman, and thank you, Mr. Leung, for your questions. There are several questions here. First, as we have set out in the paper, we expect that in terms of the tax foregone, that would not be very substantial in terms of the tax foregone. And the reasons have been explained by Mr. Chiu. And second, do we just rely on this tax arrangement or tax exemption to attract private equity funds to come to Hong Kong in promoting this development? We would not say that. We would not say that we rely merely on this tax initiative to attract private equity funds to Hong Kong in developing asset management and related services in Hong Kong. If you look at our position and also our strengths, there are different considerations. When a particular entity decides if it wants to come to Hong Kong to set up its base, of course it has its own different considerations, including the support facilities in our financial center, the regulatory regime, and also in terms of the liquidity of our market, and also how our market connects with other markets, and also in terms of asset distribution, would that facilitate their operation? And also when they set up their base in Hong Kong, do we have appropriate talents to provide the services? And of course, tax is one consideration. So we would not deny that in our contacts with the trade, some have made some relatively strong suggestions. So in our presentation, we said that back in 2013, the FSDC also made this comment, and after taking reference from the then FSDC concerning tax arrangements, it has reflected some demands from the sector and recommendations. And last, on how many professionals can benefit from this initiative, well, today I may not be able to come up with a very scientific and specific number in terms of my forecasts, but then in answering another member's questions, we also said that in 2006, when we introduced some tax initiatives in terms of our overall asset under such management, there was more than double increase in terms of the volume. So that might be a reference for the honourable member. In rolling out policies and initiatives, our primary consideration is that we would like to create a more conducive operating environment, both in terms of our financial sector and also our business sector, so that if the sectors are allowed to operate as to how they run themselves and what their considerations are, they would also have to consider the prevailing market environment in deciding whether they'd like to come. So, of course, we can take our own initiative by rolling out certain measures, and in improving our overall investment environment, and also improving our financial operations. We hope that this measure will help beef up our status. Chairman, I think the Deputy Secretary has avoided has avoided my question. Yes, I'll defer to Mr. Chiu. Mr. Leung also asked about tax arrangements. Can I supplement? Well, as I've been saying, the amendment bill would apply to non-resident funds. So they are not residents of Hong Kong. So what profits would be exempted from tax? So if they acquire a private company, and this company is not a Hong Kong company, it does not engage in business in Hong Kong. But then I have to emphasize one point. That is, we've been saying that this fund is not a resident taxpayer. And of course, in the U.S., for this investment company, this is a portfolio company. It is not in Hong Kong. For example, it might be a mainland company, and the source would of course be the mainland. So if they sell this company and if there is profit, then of course the mainland authorities can charge tax. You will have to understand this because Hong Kong's tax rate is low, and if we want to charge tax, then at the technical level, we may also have to consider the tax credit. But then the outcome might be that we might not be able to get anything. But then under our Inland Revenue Ordinance, if we were to introduce this certainty, then these offshore funds would be making Hong Kong as a hub so that it can make use of Hong Kong's professional asset managers and also accountants and lawyers to assist it, so that this regional private equity fund can run its business in Hong Kong. As I've emphasized, with regard to asset management, so for the asset managers, if they make any profit, then we will charge them tax. That's why in terms of tax revenue, in fact, there is no reduction at all. In fact, there is a very high chance that we might be able to get more tax revenue. And just now, Mr. Leung has also pointed out several points. In the event that the relevant transaction is caught by this Inland Revenue Amendment Bill, then obviously there will not be any tax charged. And Mr. Leung also said, if it's not covered, then will there be tax paid? Then we will also have to consider rather basic criteria. Number one, is this a capital profit? And if yes, then we basically cannot charge tax. And also whether the profits might have derived from offshore business or engagements, then that would also be not tax chargeable. So the benefit of this is that that would provide some certainty to offshore funds as to how Hong Kong authorities deal with the profits that they have made. So if the profit has derived from the sale of a company that is outside Hong Kong, then that would not be tax chargeable. Chairman, I hope that would be recorded in detail because as a lawmaker, Chairman, of course you know my origin. All right, if these people are speculating in Hong Kong, they should pay tax. And now we are exempting them tax. Then, of course, part of our revenue will be foregone. And that revenue can be used to deal with many problems in Hong Kong. Yes, the Financial Secretary is now a Scrooge. I hope that he will make amends before it's too late. Still, we will be foregoing some revenue. That's why I'm concerned. And of course, the Deputy Secretary and the Deputy Commissioner have not answered my question squarely. I think my question is very simple. All right, as a lawmaker, we would like to know that when in enacting this amendment bill, is it that we are dealing with an existing operation and we are trying to translate that into law? So, in English, are we codifying an existing practice? And if the answer from the officials is in the affirmative, so if you say that yes, we are simply codifying an existing practice.
Tax loss， 咁呢個係一個記錄上嘅答案。
Then that's a reply on record. In other words, we have obtained the confirmation from the executive that is when they asked this council to enact this piece of legislation, it's just codifying an existing practice, and there is no tax foregone whatsoever. There is no loss in revenue whatsoever. It's just codifying an existing practice. But then I believe that our officials would not be adopting what I just said lightly. And if you were to take that as an answer, then you will have to provide us with information. You will have to substantiate your claim. And if you are not able to substantiate that, and if you're going to give us a different reply, I hope that you can give us something in writing next time as to what your reply is. And this reply is what I'd like to know. Chairman. Deputy Secretary, can you provide us with a written reply? Thank you, Chairman. Let me answer the question this way. At present, if members would like to get further information, of course, we are happy to oblige. But then you ask if we are merely codifying an existing practice. My answer is in a negative. What I'd like to point out is that, well, you have to understand it. You have to understand how private equity funds operate. First of all, when they operate, generally speaking, so there is a life cycle, using a technical term. So they would identify the investment item, and then they would have to make an assessment. They will have to raise funds. They will also have to manage it. And then in the end, they would try to sell off the investment item. So the whole life cycle would be for 5 or even up to 10 years in some cases. That's what I'd like to point out. So when private equity funds operate, they would not just be investing in securities. That's not the type. So they would be investing in private companies. So they would be investing for 5 to 10 years, and there are standard procedures to follow. So at present, if there is no tax certainty,
then for non-resident funds, they will not consider using our professional services if we don't provide the exemption. They won't get a lawyer to do the drafting. They won't get a Hong Kong accountant to carry out the assessment. And then it will be difficult for us to justify our call for the money to be taxable, because the fund itself is not in Hong Kong, and then the investment project is not in Hong Kong. If they don't use the Hong Kong professional services, then the link with Hong Kong is very low. If we say that it is still taxable in Hong Kong, then I don't think the legal base is that sound. On the other hand, the amendment bill makes it clear. Now, even though you're using Hong Kong lawyers, Hong Kong professionals to assess the prospect of an investment project, or even you ask a lawyer to draft the agreement on the basis of Hong Kong law, now we are saying that despite that, it is not taxable in Hong Kong. So to answer Mr. Leung's question, we are not codifying an existing practice. It isn't as simple as that. We are now trying to attract non-Hong Kong funds, and they are buying and selling projects outside of Hong Kong. We welcome them to come to Hong Kong, and we are exempting them from tax. Say, for example, it may very well be a U.S. company taxable in the U.S., and the investment project is on the mainland and subject to mainland taxation. Now, we are not making it taxable for the buying and selling of this non-resident investment project. But then Hong Kong professionals will be employed to provide service, and then when they get an income, it will be taxable. Follow-up? Yes, I heard the answer. Mr. Chairman, I think you yourself asked a question earlier on, that is, we need to balance the pros and cons. I'm really at a loss. I've listened to 2 rounds of answers from the department and the bureau, but I find it difficult as to how I should interpret such an answer. Now, you're saying that Hong Kong won't, as a result of the enactment of the bill, suffered from a loss in taxation revenue. Now, I want to know whether you're saying that theoretically there is, but in reality there isn't. Maybe I don't know too much about this, and so I found myself not able to understand it. So it may very well be my ignorance. I find it difficult to know how to interpret the answers from the government. Time and again, you talked about lawyers and accountants having to pay tax. When we provide service, we are taxable. Our income is taxable. We wish we don't need to, but of course we can't. I think we need something clearer. So are you saying that in theory there is, but in reality there isn't, or it is not taxable both in theory and in reality? I find it difficult to understand your reply, so I suggest that if at all possible, please provide a paper to the Bills Committee. I think it will be recommendable. Are you going to provide a paper? Yes. Mr. Ng Leung Sing. Thank you, Mr. Chairman. I hope Mr. Leung is just a bit too concerned. I think we can show the members the practice in Singapore. So when the government prepares the paper, we can also look at the case in Singapore. Of course, the GDP won't be affected just by PE. 18 years ago, the GDP of Singapore was only half of that in Hong Kong. Now we've been overtaken. And you can see that the gap is widening. We need to liberalize our thoughts in areas like this. Competition is keen. Now, taxation initiatives will play a key role in whether we can attract newcomers to our financial center. Paragraph 22 talks about the financial implications. It is clear that income sourced from Hong Kong is subject to tax for offshore funds when they make a profit. If it is not derived from Hong Kong, if it is from outside Hong Kong, then as we have double tax avoidance, then it is not taxable in Hong Kong. I think it is just obvious. Maybe the government can, in addition to what is written here, tell us more as to how much more business will be attracted. So as to the worry that there will be huge losses on the part of the government, I don't think this is likely to happen because it is subject to overseas tax because it is an overseas business. I think we can assess the amount of PE funds that will be attracted to Hong Kong. We have got many funds looking for an outlet. And for the mainland, the policy of going out means that there will be more and more funds like this to be set up, and then they will join hands with Hong Kong. They will go out, they will make a profit outside, and then for the profits that they are going to make, they don't have a source from Hong Kong. Their investment will also involve innovation and technology enterprises or infrastructural designs. So many intermediaries and professional services will benefit. Mr. Leung, as to your concern, yes, we can have a discussion, but it will be better to be the early bird, and we can have the early bird advantage. We need to make sure that we are more attractive than Singapore. For those who have already established themselves elsewhere, then we need to do something in terms of our taxation regime. We want to have certainty. And of course, the environment itself is also important. I'm not trying to politicize the matter, but then they would like to have a better environment. We hope that our banking industry may also benefit, say, even if they don't have other things established in Hong Kong, but the mere fact that they have their money deposited in Hong Kong, we will still benefit, because some of the money will find its way to, say, securities, etc. So all in all, Hong Kong will benefit, and therefore I have an open mind. And if we want to do anything about it, we have to move quickly. It's good for a paper to be prepared to talk about the estimated benefits just to justify our support. I think it's a good point. I don't think you need any reply from the government. Next, Mr. Kenneth Leung. I think just now, Alan would like to get evidence-based information. Maybe I try to tell you how I interpret it, and then I can assist the Bills Committee to scrutinize the bill. Since 2006, tax exemptions have been given to offshore funds. To me, if we want to get useful and relevant data, I'm of course not familiar with the internal operation of the IRD, but I think that since 2006, you must have granted exemption to many offshore funds. I want to know how many of them, as a result of selling overseas private companies, selling the securities of overseas private companies, you have succeeded in charging profits tax. So, Mr. Chiu, please talk to your assessors. Try to find the statistics. I'm not sure whether you have got it, but of course I have been taking things for granted, and I think you have such figures. Say, for example, on the other hand, since 2006, you have never collected any data in relation to offshore funds selling the securities of overseas private companies and have been paying tax to you. I think such data can satisfy Mr. Leung's question. So I'm making such a suggestion. Mr. Chairman, allow me to ask one more question. For the tax exemption proposed here, it is for the securities of overseas private companies. Are we talking about shares? Because someone in the industry has asked this question. If you don't invest in the shares, if you invest in the bonds, and of course we're talking about a private company, not a listed company, they want to know whether they will get any help from the bill. Mr. Chiu, for the suggestion made by Mr. Leung, the IRD will follow up. We'll try to see if we have got the relevant data. That is, since 2006, offshore funds have been selling offshore companies, and he would like to know whether profits tax has been imposed. Now, for the bill before us, we are going to cover shares and securities of private companies offshore. Next, Dr. Low. Thank you, Mr. Chairman. This morning, I already asked a question about background information. That is, I want to know about the business prospect of PE funds in Hong Kong, as well as our share in Asia. The paper, or rather the PowerPoint presentation, gives us this figure, 21% of Asia's total, and currently 360 companies in Hong Kong. I think we have got a few competitors in Asia, so please give us the corresponding figures of our competitors. like in Asia, in Singapore, how much do they account for Asia's market? China is doing very well in the PE market in Asia, so it is at the top of the league table. We will come back to gather the information to give you the latest precision. Yes, after the meeting, we'll try to see if I've got something more updated. We'd like to find out the information from the industry. Currently, PE is not fully regulated, partly under the SFO, partly not so, because usually they invest in private companies. Give us time to find out the latest picture. Mr. Chairman, exactly as the Bureau has said, in Hong Kong, maybe we may not have easy access to such information.
I understand that if you look at the activities engaged by private equity funds, they would mainly be focusing on new startups and also some private companies. And for the I&T sector, it's a very important source of fundraising. And also to the private equity funds, the most attractive point is that the growth could be rather staggering. So, for example, this morning I was citing the example of Alibaba, and they are still having just a team of 10 odd people, and they work very hard, and as a result, the return can be very high. So for the private equity funds, by the end of 2014, it went up to some $114.6 billion US. So is the information accurate? Because if private equity funds are mainly investing in private new startups, so how did you get the information? I'd like to know that, Chairman. Deputy Secretary, as we have set out in the paper, concerning private equity funds figures, we have made reference to some published figures by the sector, and I suspect that Dr. Low, you'd like to know the investment areas, for example, on new startups and also venture capitals. We have to collate the information before we supply that to you. We hope that we can provide more information to members, but let me stress once again that for the time being, some figures might have to be obtained from the sector. We believe that many of these operations are quite sizable, and they've been formed for some time already, and I'm sure the information provided by them would be of reference value. So we'll provide the information later. Any questions? I think it's about time. So let me say this in conclusion. Well, for the proposal submitted by the government, I am positive about this. Yes, in terms of tax revenue, there might not be some obvious impact, but then we must not ignore the invisible contribution to our economy. For example, as the Deputy Secretary said, we would be able to support the professional services, the lawyers, the accountants, and so on. And as Dr. Low Wai Kwok said, they could also invest in some private IT company, and that would be very conducive to our economy. And one last point, Hong Kong is an international financial center. If we do not have any tax concessions to attract these funds to base in Hong Kong, then in terms of our competitiveness, we would also be seriously undermined. So I think this tax exemption will contribute significantly to our future financial and economic development. But then if we are going to offer this tax exemption, will we be giving people the impression that you're actually becoming a tax haven? So can we publicize it more positively? Yes, we are offering this tax exemption, but then for other sectors in Hong Kong, and in terms of professional services and employment, and also new IT startups, that would benefit those sectors a lot. So that we are trying to strike the right balance, and I believe that this bill should be supported. All right. It's now 10:20. Just now, Mr. Kenneth Leung asked to hold a public hearing, so we'll schedule the public hearing and notify members accordingly. Yes, Ms. Chen Yun-Han, Chairman. Recently, there has been a very serious clash of meetings, and I hope that you can inform me earlier, because every morning I've been having many meetings. So we are having a hard time in attending meetings. So please inform me in advance when the public hearing can be held. Yes, I support the main principles here, but then still I'd like to listen to the deputation's views. So please do let us know. Well, we still have about 10 minutes to go before the end of this meeting. So should we continue? Shall we move on to clause by clause, or should we leave it to next time? I think it's better to do it after meeting with the deputations. Chairman, in inviting the deputations, I hope that you will invite those who have spoken on this bill at the consultation stage. So can you write to these deputations of groups and trade representatives? I'm not saying that all of them would like to come, but then I'm sure the FSTB should have a list of those institutions or groups that have expressed their views on the bill. Yes, Deputy Secretary. Yes, that can be done. Okay, without further ado, the date of next meeting. Any suggestions? Chairman, I hope that there will not be any clash with the subcommittee on protection, on retirement protection, and also the welfare services panel. Well, I agree. If you ask me, of course, I will give you the reply. And if we can accommodate everything, then of course that's the best. Okay, we'll inform members as early as possible once we have scheduled the date. So without further ado, the meeting is adjourned. Thank you.